It's the time set for argument in the matter of Wales et al. Versus Arizona Corporation Commission, our civil number 19-0345. Each party will have 20 minutes within which to present their argument. This morning, the appellant may reserve some portion of that for rebuttal. It's up to you to keep track of the time in that regard. We have read the briefs, we've been through the record, we're familiar with the arguments raised, so please keep that in mind as you make your arguments here to us today. The appellant may proceed.
May it please the court, and good morning. My name is Brian Mueller from Sherman Howard, and I apologize in advance about my voice. It's not usually that good to begin with, and it's kind of going downhill, so my brief comments will be made even briefer to kind of solve part of that problem. But this very court said in the Adams versus Industrial Commission case that if the administrative decision maker and this court are both reaching a decision upon the cold record, the integrity of the legal process not only falters, it fails. The legal process failed the whales in this case. They are facing a judgment of almost $1 million if you include the prejudgment interest. And based on that, and the party that have decided that is not the party that heard the witnesses, it's not the party that received the evidence. The administrative law judge who heard all that didn't write the decision, and that decision was then sent to the Arizona Corporation Commission, who did not review the language. They simply took this recommended finding, and based on that, they're sitting looking at almost $1 million. And that is a fundamental error here. They are entitled to a new trial.
So, counsel, is your argument really that because the issues here have important credibility determinations, that it was important for the ALJ who observed the witnesses should be the one to create the decision, or the recommended decision?
In our answering brief, we have on page 12, 13, 14, we lay out the various issues which opposing counsel and the Arizona Corporation Commission have argued the credibility of the witnesses. So now they're saying it doesn't matter, but all during the process they argued the entire time that credibility was important. And so yes, that is exactly my argument. My argument is if you're going to look at the credibility of the witnesses, which again we've listed all the times what they have, you have to actually hear them.
How do you square that then with the existing case law that seems to approve or allow, might be a better word, this exact scenario?
I don't know what existing case law there is. The existing case law that I know of is the Adams case. The existing case law I know is the Ohlmeyer case. If you're talking about a couple memorandum decisions, that doesn't count. In fact, it was the memorandum decision, the Schudeck case, that was offered to the Arizona Corporation Commission as justification for why the same ALJ who saw the witnesses didn't write it. That was improper.
Maybe I'm misremembering this, but isn't the case law you're citing a situation where the substitute ALJ, for lack of a better term, was actually issuing the final decision as opposed to a recommended disposition that would then be independently evaluated by the ultimate decision maker?
And I'm glad you brought that. The Arizona Corporation Commission doesn't independently recognize it. They don't go back and read the depositions or read the transcript.
Well, you say that. Is there anything in the record that says that they didn't review the record because they're provided the record?
I cannot point to a point in the record that says...
I'm sorry?
I cannot point to any place in the record that says, no, we did not read it.
And don't they hold an independent hearing where they review the recommendations, they ask questions, and in fact, both sides had a fair opportunity to argue their position to the Corporation Commission?
There was an opportunity to argue, yes. At which time the commissioner said, Did that person testify? And so, if they don't even know who testified at the hearing, obviously they haven't gone back and reviewed the transcript.
Well, isn't it a fair to say it also might be they didn't remember that point, but that they'd asked to make sure and clarify? I mean, you can't really say that they didn't know or didn't review the record because they asked that question. I'm asking questions right now, and I have.
Yes. Well, unfortunately, I wasn't there.
Okay.
And so,
And isn't the other thing that the case law says that when you have this independent level of review, they have the opportunity to review credibility, and they can also make a credibility determination at the Corporation Commission level. And as long as, if they find that they disagree with the credibility findings of the person who wrote the decision, they can make that finding on the record.
I will defer to your statement because I'm not aware of what case law says that. But again, I'm not going to argue with it. I'm just saying, off the top of my head, I don't know where it says that, but I will. If you say that's what it is, it is. But I think that the actual practice is different. Opposing counsel can come up and tell me that I'm absolutely wrong, that I don't believe that to be true. But it's my understanding, and again, it's not in the record, so you're exactly right. Can I point to something? No. But I can point to the fact that even if they have a chance to look at it, it's not the same thing. It's not the same thing.
Well, then, would you challenge their ability to make an independent decision if they didn't? Are you saying that the Corporation Commission themselves have to handle the hearing because they are the final determiner or decider in this situation? Is that the only way that you get due process?
I think I get due process by at least having. If there's a procedural step there, as you suggest, am I saying that it has to go to that point? Probably not, because that changes everything. What I'm saying is at the very least what the whales are entitled to is that the person who heard the evidence write the recommended decision, and that's not what happened.
Counsel, I think the problem we're having is we rely on Adams versus Industrial Commission of Arizona, and in that case, true, it does state that, and I quote, the present case demonstrates the need to have facts found by first-hand observers, which goes to the point you've been trying to make. But in the footnotes, it recognizes the distinction between the situation in that case and what is happening here. And it states, and I quote, we recognize that where final administrative decisions are made by agency boards or commissions, the commissioners themselves need not personally observe the witnesses. Doesn't that completely contradict your client's position in this case?
And again, I would disagree with that because again, they are reviewing a recommended. They're reviewing a recommendation. That's what they're doing. And I guess my question would be, and my suggestion would be, in this case, I would, as burdens shift back and forth, shouldn't now the burden be upon the Arizona Corporation Commission to say, yeah, we reviewed it. That's not in the record either. It's completely silent. And when you have something this fundamental here about being able to address it, that's why this court relies upon all the factual determinations of the trial court, because they say, well, we weren't there, we can't determination, we're going to defer that to the person.
Doesn't the record at least suggest strongly that the ALJ carefully, the substitute ALJ, to use a phrase, carefully reviewed the record? The proposed order, recommended order, was very detailed, made very specific citations to the record. And so there appears that with substitute ALJ, there was a very careful review of the record, and he indicated he did so at the commission.
Yes, but if you take that and you accept that premise, that means I never need to see a witness. Never. I never need to see a witness because I'm going to carefully review his transcript. I'm going to carefully review his testimony. You can go take that, some warehouse, and then I'm going to carefully review it. And what I'm saying is that's not what the law says. The law says it's important to see them and to watch them and review them, and that's not what happened.
But doesn't the law actually say differently, which is if the ALJ is making a recommendation, then the board hears from the ALJ. The board never, or commission never hears from or sees the witnesses. In fact, the Strickland case that I was talking about is the case that specifically says, with regard to the medical board, who is making the final decision based on recommendations. Because the board, not the ALJ, issues the final administrative order, the board is not bound by the ALJ's finding of fact, including those related to the board.
And that's a very good point, because they're relying upon the people that actually saw the witness, which didn't happen here, right? I'm the board. I'm going to rely upon the recommendation of the ALJ, but I don't even get the person who saw the witness. I'm 2 steps removed from that, and that's why this is different.
So your argument is essentially that in this particular case, demeanor was important. It's not just a matter of the factual testimony, what was said, but the demeanor was important, and it goes to the crux of the issue here, because there was a credibility debate.
Yeah, it's always important. It's always important about how they provide that. In fact, and jurisprudence repeats that over and over again, that you have to be able to see them and observe them.
Well, in that regard, though, didn't the ALJ also rely on deposition testimony in the ALJ? The very record that we're talking about includes deposition testimony where the ALJ would not have been able to see the witnesses and make these judgments that you're talking about.
Certainly that's part of it, but not the entire.
And that's not an inappropriate thing.
No, it's never an inappropriate
So
thing,
why
but
is
it's not
it
the entire
inappropriate?
thing.
Why is it an appropriate thing for the commission and the substitute ALJ to be able to do that?
I guess that I understand a distinction that I'm not communicating very well. Is that can it be part of it? Can there be a part of it? Transcripts. There's part of it. Transcripts when you read into a deposition anytime. But
Why don't we switch to something different?
Of course,
In a
yes.
second, let's assume that we are looking at whether or not they were registered securities, and that had to, or whether they were subject to an exemption.
Yes.
So, where in the record do we find that your client raised the issue of I always have to look, the limited public offering before either the ALJ or the commission?
I've laid that out in my brief, and I can look through it very quickly and tell you. But off the top of my head, I would have to look through and tell you where it was. That was raised, and we did address that in our briefs. I don't have it memorized, unfortunately. But let me,
Go ahead.
if I may, with regard to that, and since we're going to jump to that in my few minutes left, I want to talk about that. It's uncontroverted that Mr. Cano and Mr. De La Casas paid no money for the stock that they were given. None. No one's saying that otherwise. Other than they're saying, well, it says something in the subscription agreement, but that's not what happened. They weren't there. The whales, it's undisputed that they did not make any payments for the stock that they was issued. There was not a sale. So that is a problem that doesn't make sense to me, that if there was no sale, it's a gift, and the law says clearly that gifts are not sales of securities. You can't therefore be fined and ordered for restitution of about $226,000 for a gift of stock.
But there isn't a dispute that they did contribute some money to the company over time. They paid some money and provided some services. Is that accurate?
They paid $50,000 a piece for licensing years before, and so that, yes, they made payments. They became involved. They became personally involved. They became directors, and for that reason, that's why they were not subject to a violation here.
So what do we do with the fact that the agreement itself said that they paid $113,500?
You do what you do every single time. It's not form over substance. It's always substance over form. You look at it's not what does the word say. It's what is the heart of this transaction. And trial courts do it. You do it all the time. We look past it The Arizona Corporation Commission looks past it all the time, saying there's a serious violation because if you look through the heart of this transaction, it happens over and over and over again. And what I'm saying, the reverse here has to be true. If you're going to say, even though it says it's not a security, it is a security, what you have to say is, even though it says it's security, it's not a security because you look at the underlying facts. I'd like to reserve the last few minutes.
Thank you, counsel.
May it please the Court, Paul Kitchen for the Arizona Corporation Commission. The substantive issues in this case are all resolved by the Wales statements. First, the Wales-owned admissions and their own statements show that they sold securities to 3 investors. Second, their own statements showed that supported the Commission's restitution order. And third, the Wales-owned statements showed that they failed to prove any exemption from securities registration. Finally, because the Wales had a hearing already before the Commission, they were not entitled to a trial de novo. Now, I would like to start with the substantive issues before getting to the trial de novo because the evidence that supported the substantive issues informed the trial de novo issue. But I wanted to jump to your question about whether or not the Commission independently reviewed the record. They did. Specifically, page 43 of the Commission's decision says that its findings of fact were made, quote, having considered the entire record herein and being fully advised in the premises. And that's record section 15, document A75.
That's the final order.
Yes, Your Honor, that's the order as signed by the commissioners. Back to the substantive issues first. The Wales sold securities to all 3 investors. And their Wales arguments now about gifting stock are an attempt to walk back the admissions they already made in their answer and the testimony they already gave during the hearing. The Wales admitted in their answer that Mr. Cano and Mr. De Las Casas, the 2 investors at issue, did invest in Visionary, their company, and that they were sold stock. Specifically from their answer, quote, the Wales admit that they sold securities in the form of corporate stock to JC, JDLC, and TW. There they're referring, JC and JDLC refers to Mr. Cano and Mr. De Las Casas by their initials.
Did they ever seek to amend their answer?
No, Your Honor. The Wales never sought to amend their answer.
But did they, during their testimony, offer a different explanation? And in fact, as often is the case, you amend the pleadings to conform to the evidence. They deny the sale in their testimony and in their presentation to the ALJ.
Your Honor, they don't even clearly deny the sale in their testimony. If you look at the testimony that the Wales cite to from the hearing, at one point in the trial, Stacey Wales alludes to there being a gift, but she also testified that the stock was given to them in consideration for their contributions. And Tim Wales testified that the Wales considered repaying Mr. Cano and Mr. De Las Casas in cash, but Mr. Cano and Mr. De Las Casas accepted the stock in lieu of cash.
Wasn't there some testimony to being cash poor at the point or low on cash resources, so the stock was given because of that?
Yes, Your Honor, but Tim Wales didn't testify, for example, that we never had to repay them. He testified that we wanted to repay them, but we couldn't. They accepted the stock instead. And therefore, the sales agreement corresponds to that. And the sales agreements say that the stock is being sold to them in consideration of the $113,250.
Doesn't it also release a number of things, including past debts and obligations?
No, Your Honor, the stock sales agreements don't refer explicitly to there being past obligations. What they do is basically speak of the $113,000 as if it had been for this all along. However the parties agreed to treat it, the parties here were intending to pay these 2 men back for the contributions they had made, and the parties went to the effort of evaluating what the monetary value of those contributions were. In addition, also from the Wales' answer, quote, the Wales admit that JC and JDLC invested in Visionary, but not the amount alleged in the complaint. I didn't put this particular portion in the brief, but this is on page 2 of their answer in paragraph 6. This, along with their admission in their answer that they sold the securities, means that they admitted that they sold stock in exchange for an investment of some amount of money, and in their answer the question was only what amount of money were they sold for.
With regard to the exemption that they're relying on, if Cano and De La Casas were in fact officers and directors, do they fall within the exception? Because I believe the allegations are that they became officers and directors. I believe the record reflects maybe some Corporation Commission documents supporting that. So if they were officers and directors, those two, wouldn't that fall within one of the exceptions?
There's a few parts to the answer, Your Honor. The first is that is the exception that they didn't raise, and they've waived it to begin with. But even if they
That's
had...
the accredited exempt.
Yes, the
investor.
limited offering exemption, which tracks whether or not one is accredited. If they had raised that, then there would be a question about whether or not the investors were accredited. But although the Wales Superior Court introduced a document, a Corporation Commission finding that purported to name those two men as directors, Stacey Wales actually testified at the hearing that they were not directors yet at the time that they signed their stock sales agreements. They only became directors afterward. That's at record section 17B4, page 275 of the transcript. So what that means is
that page?
page 275 through 277 of the hearing transcript. What this means is that even if the Wales had raised this issue before the commission and they didn't, it would have been a fact issue. Was the document correct, or was Stacey Wales' testimony correct? And the fact finder, the commission, would have had an opportunity to weigh in on that, but they didn't raise that exemption. They didn't raise...
Why then did the commission include in its findings that none of the three were accredited investors?
Your Honor, the commission didn't quite find that, but the commission found is that the Wales didn't have enough financial information about them to know whether or not they were accredited investors. And that goes to the other exemption they did raise. The exemption they did raise is the non-public offering exemption. Part of the test is did the Wales direct their sales efforts in a limited fashion to people whose financial situation they knew? So whether or not they knew the income and net worth of the investors was relevant to the non-public offering case law test. They happen to refer to the accredited investor because that sort of cross-references income and net worth. But they didn't make a finding that anyone was or wasn't an accredited investor. And the Wales never asked them to make such a finding. If you look at the Wales post-hearing brief, accredited investor isn't mentioned at all. The limited offering exemption that they are mostly relying on now, they didn't raise it in their answer. They didn't raise it during the hearing. They didn't raise it in their written closing arguments after the hearing. They didn't raise it in their exceptions to the commission's proposed order. And they didn't raise it verbally during the commission's open meeting. The first time they ever raised that exception that's based on rulemaking, the limited offering exemption, was in the Superior Court appeal. And even if they had raised it, and even if the investors were accredited, and there's no finding that they were, that exemption has multiple other requirements. They had the burden to prove those because it's an affirmative defense. The commission would have had an opportunity to weigh in on those, although the Wales already admit in the Superior Court that they didn't file a Form D notice, which is one of the requirements. In their brief here, they
that had to be filed within 15 days, I believe?
Exactly. Within 15 days of the first sale, Your Honor. The Wales attorney in the Superior Court admitted that there was no evidence in the record that they had ever filed that. And their argument in the Superior Court was, it's an insignificant deviation, we weren't required to file it. And now their argument is, the rule just doesn't require it, and it's incorrect. The provision is AAC R 144126, and it's 126D, which is the Form D notice filing requirement. And they already conceded that there's no evidence that they made that. So finally, the limited offering exemption, the non-public offering exemption, the exemption they did raise, their own statements demonstrated that they failed to meet it because to prove that exemption, they needed to prove that none of the people who were offered the securities needed the protection that would have been provided if the securities had been registered. And this required them to prove the exact number of who all the offerees were and the exact identity of who all the offerees were. And it's not enough to prove who actually invested. They needed to prove everyone who was solicited to invest, regardless of whether or not they did. And they failed to meet that burden. The commission found, quote, the Wales respondents did not establish the actual number of offerees that were being sought as investors and visionary. And that's from page 41 of the commission's decision. At this stage, at both levels of the appeal, the Wales have simply argued that there were no other offerees. I'm sorry.
What in the record supports the idea that there were other offerees?
Primarily, the testimony of Tim Wales himself, who said that the company was always looking for new investors. He also said any startup that tells you that it's not looking for investors is lying. Stacey Wales and Tim Wales both testified that their chief financial officer, a man named Brower, was out looking for investors. They testified before the hearing that they had actually hired him because he knew potential investors, in part, and he was tasked right away with finding investors. Stacey Wales testified that Mr. Cano and Mr. De Los Casas were out seeking investors, and that on some occasions those two men came to her and asked for company documents that they could provide to potential investors. The Wales don't know who those potential investors were, and without proving who they were and proving the circumstances of those offerees, they can't meet that exemption. Finally, the Wales were not entitled to a trial de novo. Here, the Wales have changed their argument. They argue in this court that it was error for the commission to delegate the drafting of its recommended order to a substitute administrative law judge. But in the Superior Court, the Wales said that they, quote, do not contend in this brief that the commission's decision to delegate the drafting of the opinion order to a different judge represents error on its part. And having intentionally not made that argument before the Superior Court, they can't now try to overturn the Superior Court's argument based on that ground. The Wales made a tactical decision in the Superior Court to not argue that delegating the drafting of the order was error. And the reason is that if the commission erred by delegating the drafting of the recommended order, then the correct remedy would be to remand the case to the commission. The commission could get input from the presiding ALJ, and then that would be that. But the Wales did not want a remand. They wanted a trial de novo in the Superior Court because that would let them change the evidentiary rules that apply. So instead, the Wales made a decision to argue the statute, ARS 12.910, which says that you can have a trial de novo in Superior Court when reviewing an administrative decision, but only if there wasn't a recorded hearing for the agency. In this case, there was a recorded hearing, so they're not entitled to a trial de novo. Also, an order from the substituted administrative law judge wouldn't have changed this. And even if the substituted law judge mattered, there's no error here because credibility ultimately didn't need to be relied on to resolve all of these issues. The Wales attorney just mentioned that they argued credibility, but they is not the Arizona Corporation Commission. The Commission's Securities Division, which was acting as the plaintiff in this case, argued credibility, but ultimately the Commission's decision doesn't make much of credibility at all, and it didn't actually need to rely on it very much. And the reason is that the substantive issues were the sales for consideration, and did they prove an exemption? Those are all resolved by the Wales on testimony. There was no need to resort to the testimony of one other hearing witness, which was Mr. White, one of the investors. His testimony simply didn't factor in because the Wales' own statements and their own admissions and their answer resolve all of the disputed issues, all of the dispositive issues here.
Wasn't there at least some level of conflict in their own testimony as to whether it's a gift or whether or not they were giving it for value, as far as or exchanging these stock options for value?
To the extent that they alluded to a gift, there's some conflict between Stacey Wales saying on the one hand it was maybe a gift, on the other hand we gave it to them for consideration. But in that case, the credibility is resolved by the fact that they already admitted in their answer that they sold the securities.
Well, that may be how you resolve the credibility, but it is a credibility issue.
Your Honor, yes, it is a credibility issue. My point is that it's a moot point because... But doesn't the Commission have the authority in certain cases for the ability of the Commission to make that credibility finding? Your Honor, you're correct. Both the Pine Strawberry case and the Ritland case agree on that point, that the Commission is its own fact finder. The administrative law judge in Commission cases is not the fact finder. They make recommendations. The Commission always makes the final decision. In the Minch case that I cited, although it's persuasive only, that case is directly on point. It's the exact same situation of an administrative decision, a recommended order for an administrative law judge. In that case, there were 12 witnesses with competing testimony. And in that case, correctly explains that Adams applies to industrial commission cases where the ALJ is the fact finder. And Ritland and Pine Strawberry apply to board cases and commission cases where the board or commission is the fact finder and rather than the ALJ.
Well, counsel, I think we've all read the transcript and listened to the recording of the proceedings before the Corporation Commission. Do you think that can be fairly characterized as a fact-finding hearing? That the corporation commissioners were independently determining the facts applicable to these issues?
Well, Your Honor, the commissioners were independently deciding the facts based on the whole record, but the open meeting is an opportunity for them to ask their most pressing questions. And in this case, the matter is resolved anyway because the administrative law judge who presented the recommended order at the open meeting was not the author of the opinion. It wasn't the substituted ALJ. It was the presiding administrative law judge who presented the recommended order to the commission. He was there to answer the commissioners' questions. They asked him questions, and his answers to those questions were all consistent with the order, the decision that the commission ultimately made. In conclusion, Your Honors, the evidence supported the Commission's findings that the Whales sold stock to all three investors. That supported the Commission's restitution order and supported the finding that they failed to prove any exemption from registration. Also, because the Whales already had an administrative hearing, the Superior Court's denial of their motion for a new trial should be affirmed, as well as the Commission's decision. Thank you.
Just briefly, opposing counsel said that credibility was not an issue, but the order, which was entered by the Arizona Corporation Commission, in which we've provided you quotes on page 13 and 14 of our reply brief, contains 1, 2, 3, 4, 5, 6, 7, 8 different paragraphs talking about the credibility of the witnesses. So obviously credibility was an issue in front of the Arizona Corporation Commission. We discussed it in our answering brief, reply brief, so his case law Ritland is 1 page. It doesn't provide anything.
Does the length of an opinion have an impact on its authoritative value or the correctness of its decision?
It does, because there's no discussion of anything. It doesn't have any discussion of what facts are operative, what law is operative. It simply says, it's like a stamp saying affirmed, we're done. It doesn't help us in determining what the state of the law is. Ritland does not help us with the state of the law.
Let me ask, is there any case in which you have the ALJ making a recommended order to a board where the situation has been resolved differently, that the ALJ, substitute ALJ, was allowed to draft it? Because it seems to me that in Pine, that in Ritland, and the memorandum decision, I forget the name, I apologize, all of them came out on the side of if their substitute ALJ was not making a final decision, the board was, or the commission, then there was not a problem. Do you have a case on all fours, purple cow case, as it were, that says, no, we disagree with that?
I do not.
Or are you asking us to be the first one to jump on that and do that?
That's never a good thing as an attorney to ask for a brand new case, but I guess that's where I am because I don't have a purple cow case. And at some point in time, someone has to be a purple cow case, and I guess that's where we are here. Because the mere statement in the order that counsel has raised, saying, having reviewed all the evidence, that is not the same as saying we have looked at the entire transcript, we've reviewed the entire transcript, and we know exactly what all the what it is. That just says we've looked at the record. I can go in my file room look at the record, and that doesn't mean that I've read it all and done it all. So I think that's a distinction. So again, what the cases say is you can have someone making the decision based on someone else's observation of the demeanor of the witnesses, which did not happen here. If in fact, in addition to that, you've also reviewed the entire case, and there's nothing in the record that says it happens, and I don't think it happened.
Counsel, I'm still trying to decide what we do with your client's position when they stated that they do not contend that the Commission's decision to delegate the drafting of the opinion in order to a different judge represents error on its part. I'm not sure I understand how that's not waiving the issue.
The issue was raised. Again, I apologize I was not there, so I can't have you read firsthand what happened and why it happened. But I do know that the issue was raised, otherwise there would not have been the decision.
Are we saying that at some point, you were not counsel, but at some point your client's position was to not pursue that argument, and now they are?
Yeah, and I guess that's what I'm saying is they've always pursued it. Why
What does that mean?
I don't know. I wish I could give you a great answer, and that's what I'm supposed to do here, but I don't know the answer to that question, because then the actions were different than what that says. They did pursue it. The trial court made a reference in their minute entry about a different ALJ writing it. I mean, so obviously it was presented to the trial court. And if it was presented to the trial court, obviously it wasn't waived. So I wish I had a really smart answer, but I don't. I have 16 seconds. And your reference to the reply brief at page 18 to 25 talks about whether, in answer to your question, you're asking about whether there was a waiver of those different.
Sorry, could you say a little bit? I know you're struggling, but
you'd ask about where could we find a discussion about whether or not certain arguments were waived or not. And I'm saying that was in our reply brief at 18 to 25.
Thank you, counsel. We appreciate the arguments presented here today, as well as the briefing that was supplied for this matter. We're going to take the decision under advisement. We'll issue a written decision in due course. We're going to take a short recess to allow counsel for the next matter to come forward and get set up. So we're at recess. Thank you.